There's also the simple fact that Americans want stronger protections for this information. But as I've started to look into these issues in greater depth, I've realized that our federal laws do far too little to protect this information. Prosecutors bringing cases under the federal anti-hacking law often rely on breaches of privacy policy to make their case, but many mobile apps don't have privacy policies, and some policies are so long and complicated that they're almost universally dismissed before being read. In fact, once the maker of a mobile app, a company like Apple or Google or even your wireless company, gets your location information, in many cases, under current federal law, these companies are free to disclose your location information and other sensitive information to almost anyone they please without letting you know. And then the companies they share your information with can share and sell it to yet others, again, without letting you know. This is a problem. It's a serious problem. And I think that's something the American people should be aware of. And I think it's a problem we should be looking at. And before I turn it over to the distinguished ranking member, I just want to be clear that the answer to this problem is not ending location-based services. No one up here wants to stop Apple or Google from producing their products or doing the incredible things that you do. And I thank you for testifying. You guys are brilliant. When people think of the word brilliant, they think of the people that founded and run your companies. No. What today is about is trying to find a balance between all of those wonderful benefits and the public's right to privacy. And I, for one, think that's doable. Now I'll turn the floor over to my friend, the ranking member, Senator Coburn, for his opening remarks.
Thank you, Mr. Chairman. I'll be brief. I just wanted you to know that weather app that you have on your phone sends me a location of all the meetings you attend, so just to be forewarned.
That makes me very frightened.
I would thank our witnesses for being here today, both our government witnesses and our outside witnesses. Transparency in what we do in government and outside of government when it's not fiduciary and when it's not proprietary is important for the American people, as is the issue of privacy. And rather than making a decision on what needs to change, I think we need a whole lot more information and knowledge in terms of those of us on the legislative side before we come to conclusions about what should or needs to be done. So I'm looking forward to our witnesses' testimony, and with that I will shorten this up and rather would hear from our witnesses rather than to continue to propound from the dais.
Thank you. I think we will begin our first panel now, and I want to introduce them. We have Jessica Rich. She is Deputy Director of the Bureau of Consumer Protection at the Federal Trade Commission. She has served as an Assistant Director in the Federal Trade Commission's Bureau of Consumer Protection since 1998, first in the Division of Financial Practices and now in the Division of Privacy and Identity Protection. She previously served as legal advisor to the Director of the Bureau of Consumer Protection. She received her law degree from New York University and her undergraduate degree from Harvard University. Jason Weinstein is the Deputy Director, Deputy Assistant Attorney General for the Criminal Division of the U.S. Department of Justice. Before joining the Criminal Division, Mr. Weinstein served as the Chief of the Violent Crime Section in the U.S. Attorney's Office for the District of Maryland. He was also an Assistant U.S. Attorney in the U.S. Attorney's Office for the Southern District of New York. Mr. Weinstein attended Princeton University and the George Washington University Law School, and I understand that your wife is very pregnant and that you may have to leave during your testimony or during Ms. Rich's testimony, and as chairman, that'll be fine if you have to. That'll be fine. So, Ms. Rich, fine.
Let me turn on the microphone. That would help.
Yes.
I am Jessica Rich, Deputy Director of the Federal Trade Commission's Bureau of Consumer Protection. I appreciate this opportunity to present the Commission's testimony on mobile privacy. The FTC is the nation's consumer protection agency, and privacy has been an important component of our mission for 40 years. During this time, the Commission has employed a variety of strategies to protect consumer privacy, including law enforcement, regulation, outreach to consumers and businesses, and policy initiatives. Just as we have protected consumer privacy in the brick-and-mortar marketplace, on the phones, on email, on mail, and on the Internet, we are committed to protecting privacy in the rapidly growing mobile arena. To ensure the Commission staff has the technical and practical ability to engage in law enforcement and inform policy development in the mobile space, the Commission has hired technologists to work as FTC staff. The agency also has created a mobile lab with numerous smartphone devices on various platforms and carriers, as well as software and other equipment to collect and preserve evidence. In addition, Commission staff have explored the key mobile consumer protection issues through workshops and reports. What is clear from our work in this area is that the rapid growth of mobile products and services creates many opportunities for consumers, but also raises serious privacy concerns. These concerns stem from the always-on, always-with-you personal nature of mobile devices, the invisible collection and sharing of data with multiple parties, the ability to track consumers, including children and teens, to their precise location, and the difficulty of providing meaningful disclosures and choices about data collection on the small screen. Law enforcement is, of course, critical to our consumer protection mission. The FTC's primary law enforcement tool, the FTC Act, prohibits unfair or deceptive practices. This law applies regardless of whether a company is marketing offline, through your desktop or telephone, or using a mobile device. In the Commission's testimony, we described 4 recent FTC cases brought under the FTC Act that address practices in the mobile arena. 2 of these cases, against 2 of the largest players in the mobile ecosystem, Google and Twitter, highlight the FTC's efforts to challenge deceptive claims that undermine consumers' choices about how their information is shared with third parties. In Google, the Commission alleged that the company deceived consumers by using information collected from Gmail users to generate and populate a new social network, Google Buzz. The Commission's proposed settlement contains strong injunctive relief, including independent audits of Google's privacy policies and procedures lasting 20 years, that protects the privacy of all Google customers, including mobile users. In Twitter, the Commission charged that serious lapses in the company's data security allowed hackers to take over Twitter's accounts and gain access to users' private tweets, as well as their non-public mobile phone numbers. As in Google, the Commission's order protects data that Twitter collects through mobile devices and requires independent audits of Twitter's practices for 20 years. If either company violates its order, the Commission may obtain civil penalties of $16,000 per violation. Similarly, in our ongoing Phil Flora litigation, the Commission obtained a temporary restraining order against a defendant who allegedly sent 5 million unsolicited text messages to the mobile phones of U.S. consumers. And in the Reverb case, the Commission alleged that a public relations company planted deceptive endorsements of gaming applications in the iTunes mobile app store. The Commission's public law enforcement presence in the mobile arena is still at a relatively early stage. But we are moving forward rapidly and devoting resources to keep pace with developing technologies. Commission staff have a number of mobile investigations in the pipeline, including investigations related to children's privacy on mobile devices. I anticipate that many of these investigations will be completed in the next few months, and any complaints or public statements will be posted on our website, ftc.gov. I want to emphasize that while the mobile arena presents new methods of data collection and new technologies, many of the privacy concerns build on those the FTC has been dealing with for 40 years. At bottom, it's all about ensuring that consumers understand and can control data collection and sharing, and that their data doesn't fall into the wrong hands. The FTC has the authority, experience, and strong commitment to tackle these issues. In closing, the Commission is committed to protecting consumer privacy in the mobile sphere through law enforcement and by working with industry and consumer groups to develop workable solutions that protect consumers while allowing innovation. I'm happy to answer any questions.
Thank you, Ms. Rich. Mr. Weinstein.
Thank you, Mr. Chairman. I've asked the baby to stay put till after about 11:30, which will probably be the last time it ever listens to anything I say. Good morning, Chairman Franken, Ranking Member Coburn, and members of the subcommittee, and I thank you for the opportunity to be here today. Over the last decade, we have witnessed an explosion of mobile computing technology. From laptops and cell phones to tablets and smartphones, Americans are using more mobile computing devices more extensively than ever before. We can now bank and shop and conduct business and socialize remotely with our friends and loved ones instantly, almost anywhere. And now more than ever, the world is almost literally at our fingertips. But in ways that we don't often think about, what we say and write and do with these mobile devices can be open to the world. And as the use of mobile devices continues to grow, these devices are increasingly tempting targets for identity thieves and other criminals. So as these devices increase our connectivity, our productivity, and our efficiency, they also pose potential threats to our safety and our privacy. And those threats fall into at least three very different categories. The first category are the threats posed by cybercriminals, identity thieves, cyberstalkers, and other criminals who seek to misuse the information that's stored in or generated by our mobile devices to facilitate their crimes. From around the corner or around the globe, skilled hackers work every single day to access the computer systems and the mobile devices of government agencies, universities, banks, merchants, credit card companies, to steal large volumes of personal information, to steal intellectual property, and to perpetrate large-scale data breaches that leave tens of millions of Americans at risk of identity theft. In addition, some of these cybercriminals seek to infect the computers in our homes and our businesses with malicious code to make them part of a botnet, a network of compromised computers under the remote command and control of a criminal or a foreign adversary who can capture every keystroke, every mouse click, every password, credit card number, and email that we send. Smartphones and tablets are, in a very real sense, mobile computers. And the line between mobile devices and personal computers is shrinking every day. So these devices provide yet another computing platform for cybercriminals to target for botnets and infection by malicious code. Unfortunately, Americans who are using infected computers and mobile devices are suffering from an extensive, pervasive invasion of their privacy at the hands of these criminals almost every single time they turn on their computers. One of the Department of Justice's core missions is protecting the privacy of Americans and prosecuting the criminals who threaten and violate that privacy. Through the dedication and skill of our prosecutors and our agents, we have had a number of major enforcement successes, including most recently the operation in Connecticut to successfully disrupt the Corefled botnet, which was believed to have infected over 2 million computers worldwide. As mobile devices become more prevalent and as they store more and more personal information about their users, we should expect that they will be increasingly targeted by criminals. It is critical, therefore, that law enforcement has the necessary tools to investigate and to prosecute those crimes, which are crimes against the privacy of all Americans. The second category of threats to our privacy comes from the collection and disclosure of location information and other personal information by the providers themselves, including app providers. These situations may or may not be appropriate for criminal investigation and prosecution. It all depends on the circumstances. Some may best be addressed through regulatory action. And as we evaluate these matters, we must carefully consider the clarity and the scope of privacy policies and other user agreements that govern the relationship between providers and their customers. The third category of threats comes from criminals who use mobile devices to facilitate all sorts of their own crimes, from traditional cybercrimes like identity theft to violent crimes like kidnapping and murder. As technology evolves, it is critical that law enforcement be able to keep pace. Law enforcement must be able to get the data it needs to investigate and prosecute these crimes successfully and to identify the perpetrators, what we used to call putting fingers at the keyboard and which I guess we should now call putting fingers on the touchpad. This kind of identification is already a challenge in cases involving more traditional computers, where data critical to investigations of cyber criminals and child predators and terrorists and other malicious actors has too often been deleted by providers before law enforcement can obtain it through lawful process. That challenge is even greater in cases involving mobile devices. Although we increasingly encounter suspects who use their smartphones and tablets just as they would a computer, many wireless providers do not maintain the records necessary to trace an IP address back to a suspect's smartphone. Those records are an absolutely necessary link in the investigative chain that leads to the identification of a particular suspect. I thank you for the opportunity, Mr. Chairman, to discuss some of the challenges the Department sees on the horizon as Americans' use of smartphones and tablets continues to grow, and how the Department works every day to protect the privacy of users of computers and mobile devices. We look forward at the Department of Justice to continuing to work with the Congress as it considers these issues, and I'd be pleased to answer your questions.
Thank you. Thank you both. Ms. Rich, in the FTC's December 2010 Consumer Privacy Report, the Commission states that certain kinds of information is so sensitive that before any of this data is collected, used, or shared, companies should seek, quote, express affirmative consent from a customer. You identify 4 categories of data that are this sensitive: information about children, financial information, medical information, and precise geolocation data. First of all, why does the FTC think that before a company gets or shares your location information, they should go out of their way to get your consent?
We identified those 4 categories because misuse of that kind of data can have real consequences for consumers. So in the case of location data, as you mentioned and your colleagues mentioned, it can lead to, if it falls into the wrong hands, it can be used for stalking. Teens and children have a lot of mobile devices, and so we're often talking about teen and children information and their location. Location can't just tell you where a person is at a particular time. If it's collected over time, you can also know what church somebody has gone to, what political meeting they've gone to, when and where they walk to and from school. So that is sensitive data that requires special protection.
Thank you. Mr. Weinstein, let me ask you a related question. When I use my smartphone, a lot of people can and do get a hold of my location, my wireless companies like Apple and Google, as well as the mobile apps that I have on my phone. My understanding, Ms. Weinstein, is that in a variety of cases under current federal law, each of those entities may be free to disclose my location to almost anyone that they please, without my knowing it, without my consent. Is that right?
That is right, Mr. Chairman. The statute, ECPA, that you made reference to that Chairman Leahy wrote 25 years ago, does provide, in those instances in which it covers the provider, and that's a separate question, it places a great deal of restrictions on the ability of providers to share that information with the government, but virtually no legal restriction on providers' ability to share that with other third parties. There may be specific types of restrictions if you're talking about data other than location, like healthcare data, that may be covered by other particular privacy laws. But if you're talking about location data, then there's no legal restriction. If the company is not covered by ECPA, that is, it's not considered to be an electronic communication service provider or provider of remote computing service, then there's no restriction at all. The company is free to share it with whoever they want.
Mr. Weinstein, one of the defining features of the mobile market is that you have a lot of different entities, app developers, advertisers, companies like Apple and Google that are amassing large amounts of information about users outside of any assurances that they make to their customers or the requirements of financial records laws. Do the companies in this sphere have to meet certain data security standards? In other words, what's to prevent them from getting hacked?
I'm not aware, Mr. Chairman, of any legal requirement that a company that is in possession of your personal data, whether we're talking about location data or financial data or other data about your use of what you do online, secure that data in any particular way. My understanding is that that's essentially a decision made by the company based on its own business practices and its assessment of risk. One of the arguments that you often hear when we talk about data retention, because there's also no requirement that the company retain data for any particular length of time, and that often impacts our ability to investigate and solve crimes, including crimes that threaten privacy. And when we talk to industry and we talk to privacy groups about the need for data retention for some reasonable period of time to make sure that law enforcement can get the data it needs to protect privacy, what you often hear is that if companies are required by law to store that data for some length of time, that it will put them at greater risk of being hacked. And it's an open question. It's certainly one for the Congress to consider whether if there were to be a requirement for data retention, whether it's also appropriate to impose some requirement that the data be secured in some way to reduce that risk.
Thank you, Mr. Weinstein. Before I turn to the ranking member, I want to introduce a few key pieces of testimony into the record. First, I want to introduce joint testimony from the Minnesota Coalition for Battered Women and the National Network to End Domestic Violence, as well as testimony from the National Center for Victims of Crime. This testimony lays out how law enforcement can use this technology to find stalkers. It also cites cases of 2 Minnesota women who were both stalked by their partners through their smartphones. These are extreme cases, but I think there's no clear statement on how this technology presents clear benefits and also very clearly privacy threats, and how we need to be very careful in this space. Now I'd like to turn it over to the ranking member, Senator Coburn. Senator Coburn?
Thank you, Mr. Chairman. One comment I'd make, I hope after you all testify that you'll hang around and listen to the second panel. What I find is in Congress a lot of time we talk past each other, and when we're observing us talking past each other, we actually learn something if we're an outside observer, and I would hope that when we hear both sides of this today, it'll actually accentuate the ability to solve the problems that are in front of us. I want to thank you for your testimony. I have a question directed to both of you, and I'd like for you to just individually answer it. Both of you have demonstrated that under certain laws that we have on the books today, you can do a lot in terms of addressing these privacy issues. My question for you is, in your opinion, what else do you need in terms of statute to actually facilitate your ability to protect the privacies of individuals in this country without diminishing the benefits that we're seeing from this technology?
The Commission has not taken a position at this point on legislation in this area. However, in the report that Senator Franken referred to, we did discuss some key protections we think should be applied in industry, not just across industry, including in mobile, that we believe would protect privacy while also allowing innovation to continue. And that first is basically companies should have privacy by design, meaning at the very early stages of developing their products and services, they need to give privacy serious thought so that they develop those products and services in a way that maximizes safety to consumer data. That means not collecting more data than is needed, not retaining it for longer than is needed, providing security for it, making sure it's accurate. Those things, if implemented early, can be done in a way that still permits innovation and still permits the business to function.
Can you do that through regulation now? Can you make those demands through regulation?
We have used Section 5 of the FTC Act, which prohibits unfair or deceptive practices, to bring enforcement against companies under certain circumstances that don't do those things. Right. The second piece is streamlined, easy-to-use choice for consumers. And that would be streamlining it and making it easy to use would be particularly important on mobile devices where we've seen we don't see privacy policies, as was mentioned in the Wall Street Journal article, and when we do, it may take 100 clicks to get to the terms of service to find them. So, you know, we've encouraged the use of icons and ways to make it easier for consumers to exercise choice about things like sharing data with third parties.
Like writing in plain English instead of lawyerese?
Yes. And then the third piece is, of course, greater transparency overall, which means if you do have privacy policies, they should be written in a simple way so they're easy to compare, and potentially a consumer should be able to access the data that companies have on them. So we believe if implemented, those protections would achieve much greater protection for consumer while also allowing innovation.
So the question I would have for you is, do you have the ability to implement that now under the FTC guidelines?
Those are policies, some of which can be implemented under the FTC Act, but some of which are forward-looking policy calls.
Would you mind submitting to the committee which are which, so that that can guide us in addressing where we think we might need to go?
Yes.
Thank you. Mr. Weinstein.
Senator Coburn, there are 4 or 5 things that the Justice Department thinks that Congress should consider in terms of legal changes, but most of them are not particular to mobile devices. A few of them are. And the reason that they're not all specific to mobile devices is I think it's important to put in perspective that the threats that you see in terms of cybercrime committed on mobile devices are really just new variations on old problems. When someone puts malware on your computer because they attach it to an email, that's a threat to your computer. If someone uses an Android app as a delivery system for their malware, that's old school cybercrime committed with new school technology. And so what we need to protect privacy is the same thing we need to be able to fight cybercrime generally. That being said, number one, there are a number of further fixes to 1030, to the Computer Fraud and Abuse Act, even beyond those that were contained in the Identity Theft Enforcement and Restitution Act in 2008 that we believe are appropriate and would strengthen penalties and strengthen deterrence and make sure that there were significant consequences, more significant consequences for cybercrime. Those we anticipate will be part of the cybersecurity package, which I told Senator Whitehouse a month ago was imminent, and now it is imminent measured in terms of days instead of weeks. The second it relates to cyberstalking. The cyberstalking statute requires currently that the victim and the defendant actually be in different states. And that significantly hampers our ability to use that statute, since, as you know, cyberstalkers, or people who harass, whether through cyber or other means, are frequently right down the street, not necessarily across the state line. The third is data retention. We think that there are, although we don't have a specific proposal, there are undoubtedly, there is a reasonable period of time that Congress can require providers to retain data that would allow us to solve crimes against privacy that properly balances the needs of law enforcement, the needs of privacy, and the needs of industry. The fourth is data breach reporting. As we see every week, we see a new article in the newspaper about another significant data breach, whether it's Sony or Epsilon or RSA, and it highlights the fact that there is no legal requirement federally, although there are a number of state laws. There's no comprehensive federal legal requirement that requires data breach reporting either to customers or to law enforcement. The fifth, which is mobile device specific, is the one I alluded to in my oral remarks, and that is that among the data that is not even maintained, let alone retained, is data that will allow us to trace back an IP address to the smartphone that was using it at the time that a criminal conversation or other criminal conduct occurred. The last piece, and then I'll stop, is, and this is not a particular proposal, but just something we encourage Congress to consider because it relates to privacy generally. As I alluded to a few minutes ago, there are significant legal restrictions on a provider's ability to share data with law enforcement. There are no restrictions, virtually no restrictions, certainly none provided by ECPA, on a provider's ability to share that information with third parties for any purpose, commercial or otherwise. And we think that Congress may wish to consider whether ECPA properly strikes that balance between privacy, the privacy balance between consumers and the providers that they're engaged in commerce with.
All right. Thank you very much. Thank you, Mr. Chairman.
Thank you, Senator Coburn and the Chairman.
Well, Mr. Weinstein, you mentioned ECPA, and I'm glad you did, because I'm going to be introducing a bill very shortly to update ECPA, the Electronic Communications Privacy Act. I think it's a very important act. Many of us have a concern it does not apply to the mobile applications currently available. And that can be bad for the consumers, also bad for law enforcement. Let me just point out the privacy requirements in ECPA only apply to providers, or either electronic communication service providers or remote computing service providers. But if Google or Apple or other mobile or application providers collect data automatically generated, say, from a smartphone, they might not fall into either of the definitions. But that would mean the government could just step in, obtain location, other sensitive information collected without obtaining a search warrant. I'd mentioned a search warrant situation earlier when I spoke, but they might be able to do it without. Does ECPA apply to providers of mobile applications? And if not, what are some of the changes we should make?
Mr. Chairman, the answer really would be the same answer I would give if you asked me not about mobile application providers, but if you asked me about Verizon or Google or Apple, for that matter. As companies provide a broader range of services, a company may be considered a provider of electronic communication service for one service it provides, remote computing service for another service it provides, and neither for some other service it provides. So even a company like Verizon is clearly an ECS for its communication services. It would be a company like Apple might be an RCS for the MobileMe remote backup service. Google might be for Google Docs, but Google might be an ECS or would be an ECS for Gmail. So a mobile app provider could be an ECS or an RCS or neither one. A lot of it depends not on the nature of the company, but on the nature of the particular service. So,
but does that mean that we have a gap in ECPA and we should be addressing it in the new legislation?
I think that as all of these companies expand the range of services they provide, there are going to be gaps. There are going to be companies, whether more traditional companies or newer companies, that provide services that don't fall in one of the two categories. And so I don't have a particular proposal, but we'd certainly be happy to work with you to explore where those gaps are and how they should be filled.
The scenario I suggested, is this something where law enforcement come in and get all this information without a search warrant, without going through a court?
Well, if a company is not covered by ECPA, then we can get stored data using a subpoena or other legal process. A search warrant wouldn't be required in most instances.
Now, you mentioned Epsilon and Sony and the breach, which as I read more and more about it, it's more and more frightening what's there. Now, on 3 occasions, the Judiciary Committee has favorably reported my comprehensive data privacy and security bill. Among other things, it would establish a national standard for notifying consumers about data breaches involving their personal information. And we'll try again this Congress to get this passed. But if there's been a data breach, your information is there. You wouldn't have to rely on the good graces of the company that screwed up allowing the data breach, but they'd be required to notify you of it. How important is it for your department and other law enforcement agencies to be notified of data security breaches so that they could look at whether it affects our criminal laws and national security? And then I'll ask Ms. Rich a similar question.
It's vital for law enforcement. If we don't know about a breach, we can't investigate it, and if we find out about it too late, by the time we find out about it and begin investigating, the trail very well may have gone cold. There are, as I think you know, 46 or 47 state laws that in some fashion govern breach reporting, but only a few of them require the victim to notify law enforcement. Some of our biggest hacking and identity theft cases, a number of which I testified about in front of the crime subcommittee a month ago, were made possible because we got early reporting from the victim companies and we got cooperation from the victim companies throughout the investigation. And that was critical to our ability to follow the trail and find the hackers and find the people who stole personal data. The two things that law enforcement needs to be able to have a shot at making these cases are prompt victim reporting and if there is customer notification, which there certainly should be, the opportunity to delay that notification where appropriate if law enforcement or national security needs dictate. But we think that data breach reporting is vital to our ability to do our jobs, and we anticipate that in this imminent cybersecurity package that there will be a data breach proposal that's contained in it.
And Ms. Rich?
The FTC has long supported legislation to require data breach notification and data security. We play a complementary role to the Department of Justice in that they pursue the hackers, the malicious folks who get the data, but our perspective is it's extremely important to also shore up the protections of those companies that have the sensitive data. There's always going to be criminals, but it's very important that companies secure themselves again, so they're not easy targets. And we believe legislation requiring notification and security is vital to that mission.
Thank you. And again, Chairman Franken, I thank you for holding this hearing. I think it's extremely important, and I'll go off to some budget matters now, but I appreciate you doing it.
Please do that. Thank you, Mr. Chairman. Senator Blumenthal.
Thank you, Senator Franken, for your leadership. Again, thank you, Senator Leahy, for your championing many of these privacy issues over decades, literally, and providing a model of that kind of leadership for us. And I want to thank our witnesses for being here, also Apple and Google and the consultants that we have in this profoundly important hearing. And whatever the kinds of challenging questions that we may ask, I hope that we are all on the same side of this cause, because right now what we face, in my view, is literally a Wild West so far as the Internet is concerned. We can debate the legal niceties and technicalities, but the FTC statutes that prohibit unfair and deceptive practices simply don't provide the kind of targeted enforcement opportunity that I think is absolutely necessary, and I know the Department of Justice is going to be seeking additional authority, which is absolutely necessary. And just one area pertains to young people, children, which we haven't discussed so far today, but which obviously raise very discrete and powerfully important issues. And so let me begin with Ms. Rich. Do you think that the present statutes sufficiently protect young people, children who are 13 and under, when we're talking about marketing, locational information, other kinds of privacy issues?
We do have a very strong law, the Children's Online Privacy Protection Act, that applies to children 12 and under. We are undertaking a review of that right now, and we haven't reached the result of that. One of the reasons we were reviewing it was to see if it's keeping up with technology, and we haven't reached the end of that. But in a workshop we had on that, there was a fair amount of agreement from industry and consumer groups alike that that statute is sufficiently flexible to cover a lot of mobile technologies and activities across a broad swath of technologies.
And do you agree, Mr. Weinstein?
I do. I was thinking this morning, I have two, soon to be three little kids, and my 3-year-old is better with my iPhone than I am, and it's terrifying actually to think about what kind of threats, online threats, will be out there by the time he's actually old enough to really be using my iPhone with permission. So I think that as we move into this space, I think it's important that any legal changes we make be technology neutral to the extent possible.
And I strongly support that requirement. I think it is a basic fundamental protection. Shouldn't there be some requirement that companies design and safeguard this information when they structure these systems, and also potentially liability if they fail to sufficiently safeguard that information? Liability so that we provide incentives for companies to do the right thing.
Absolutely. We brought, using Section 5, 34 cases against companies just in the last, 5 or 6 years against companies that fail to secure data, and we believe it's vital to hold companies accountable for that.
And what about a private right of action?
Commission hasn't taken a position on legislation or private right of action.
Because we had testimony from Professor John Savage of Brown University, who said to us, and I'm quoting, "Computer industry insiders have solutions to many cybersecurity problems, but the incentives to adopt them are weak, primarily because security is expensive and there is no requirement they be adopted until disaster strikes.
Let me correct something I just said. The Commission has actually taken a position on data security. I was a little confused by the question. We strongly support data security and data breach legislation, absolutely, which includes civil penalties.
Thank you. My time has expired, and I will be submitting some additional questions for the record. Thank you both.
Senator Whitehouse.
Thank you, Chairman Franken. Quick question, then a slightly longer one. The quick question is that both of you have had a chance to look into the, you might call it the dark side of the Internet, the dark underbelly of the Internet. And you're also people who use it and have families who use it. And so you both have the experience of the regular American at dealing with the Internet and having a certain measure of confidence in it. And you have a heightened awareness based on your professional obligations. Based on that, how well informed do you believe the average American is about the dangers and hazards that lurk out there on the Internet? And is this significant in terms of things as simple as willingness to download protective patches and get up to date with commercial off-the-shelf technology to protect yourself, setting aside other responses that the public might have if it were more informed? Can you quantify a little bit how well informed you think the average American is about these risks?
We believe that consumers really have no idea of the layers of sharing that go on behind the scenes. So, for example, many consumers may like the location services and they may want to share their location information in order to obtain them. What they don't realize is that their location data as well as the device ID may then be flowing to service providers, to advertisers, to all sorts of other parties in the chain. And we believe that that's why when certain high-profile security breach happen at companies like Epsilon, who are service providers and behind the scenes, people are so shocked because they had no idea their data was there.
Weinstein?
I think with the large population that we're talking about, I think that there's going to be great variation, but I venture to say that and this is based on sort of professional and personal observation, that the vast majority of people are not as informed as they should be. And in fact, if nothing else comes out of the heightened awareness that the Apple and Google media frenzy has created and that this subcommittee's interest has generated, I think it will be that people focus more on these issues. The fact is that these kind of situations may or may not be criminal enforcement matters, but what they do highlight is the need for everybody to be more vigilant. Undoubtedly, providers can take steps to make sure that their user agreements and their privacy policies are more transparent and are easier for the average person.
Jump into that, if you don't mind, a little bit. Earlier in your answer, you basically set up the traditional dichotomy, if you will, between a legitimate communication or application and something that is infected with malware and is probably a law enforcement problem if it could be discovered. We're now in a new area, kind of in between those two, where the product might actually be something that the subscriber would want. I can imagine a location application that told you whenever you were near a particular fast food restaurant so they could ping you and say, come on in for a Big Mac or whatever it would be. And that might be something that somebody would want. It also might be something that somebody would really not want at all. And I think part of the concern here is that if you're loading an app, for instance, onto a smartphone, you know that you're loading one dimension of the app. You don't know what else is being attached onto that. And what should the FTC be doing by way of disclosure requirements to make sure that when you load an app, whoever has put that app on the menu, really, for people to choose among, has fully disclosed that all of the elements are in it, and it's not just a Trojan horse to attract you with a particular thing when its real purpose is to find out information about you to sell to other individuals. Where are you in terms of getting that transaction properly overseen and with some rules, I guess what you'd call privacy by design in your earlier statement?
It's challenging in the mobile sphere because of the nature of the small screen, but the FTC has called on industry to develop simplified disclosures that are embedded in the interaction. So, for example, if when you're downloading the app, if they're going to, share the information with third parties, they've got to tell you that there and then, not in some privacy policy that, would take you 100 screens to download and look at. So, I think there needs to be serious work done to improve the interaction between these companies and consumers. And we also don't think that if it's not necessary to share for the business model, if it's not necessary to share with other companies for the business model, it shouldn't be happening. We've also seen that when sometimes sharing is necessary for the business model, instead of sharing the limited slice of information that's needed, they pull the information off the whole device and share it with third parties. So that's the privacy by design piece.
And from your point of view, the Trojan horse analogy for some apps is a fair one.
Yes.
Okay. Thank you.
Thank you, Senator Whitehouse. I'm going to have one more question here for Ms. Rich, and the ranking member has one more question. Ms. Rich, in your testimony, you're just talking about the little screen and signing off on privacy agreements anyway, in your testimony, you emphasized the FTC's ability to protect consumers against deceptive trade practices. When an iPhone user activates their phone, they have to click and agree to a 4,144-word software license agreement. And that tells users they can withdraw their consent to Apple's collection of location information at any time by simply turning off the location services button on their phones. I'll add a copy of that agreement. This is it. To the record. As it turns out, until about a week ago, turning off the switch did not stop the collection of location information by Apple. So I guess my question is, Ms. Rich, is that a deceptive trade practice?
Well, I can't comment on a specific company's practices, but I can say that if a statement is made by a company that is false, it is a deceptive practice. Similarly, as we've shown in our cases, if there's a misleading statement and then some sort of disclaimer in fine print, that could be a deceptive practice. So there's a lot we could do under our deception authority to challenge the types of practices you're talking about, although I'm not going to comment on the specific company.
Thank you. Ranking member.
Mr. Chairman, I just have one comment. I think we need to be very careful on this idea of security, because the greatest example I know is we spend $64 billion a year on IT in the federal government, and then on the top of that we spend tens of billions on security, and we're breached daily. So we should not be requesting a standard that we cannot even live up to at the federal government. So the concern is an accurate one, but I think we're going to have to work on what that standard would be, whether it's a good faith effort or something. But to say somebody's liable for a breach of their security when we all know almost every system in the world can be breached today, we need to be careful with how far we carry that. That's all I would add.
Can I just address that briefly to say that we agree there's no such thing as perfect security, and we've always used a reasonableness standard. Many of the types of practices that would prevent breaches are things like not collecting more data than you need.
I agree.
Basic.
Senator Blumenthal, do you have another question?
Yeah, just to follow up on Senator Coburn's observation, as with any kind of liability or accountability, legal responsibility, there's a duty of care, and that duty of care can impose reasonable measures that common sense or technology would provide the means to do. And so I guess my question is, why not some liability to ordinary consumers imposed through federal law that would impose accountability for a standard of care that is available under modern technology with the kinds of reasonable approach, a sensible responsibility.
Yes, Senator, we agree with you. In the data security sphere, it's reasonable security. It's having a good process that assesses risks and addresses those risks. It's not perfection.
And why not also require remedies in the case of a breach where that kind of accountability is imposed, for example, insurance or credit freezes, credit monitoring as a matter of law, so that what is increasingly becoming standard practice would be imposed on all companies and provide the incentive to do more.
Absolutely. We think that's important both to address what's happened to consumers and provide effective deterrence.
You agree, Mr. Weinstein? I know you're speaking out of the consumer protection area, but...
Well, I'm trying to stay in my lane, but look, I think I'll make the general observation, and I think this touched on some issues we talked about at the hearing last month. There is no perfect system. Cybersecurity, true cybersecurity requires sort of multi-layered approach, requires laws that breaches be reported. It undoubtedly requires providers to take as much of an effort, make as much of an effort as they can to protect their systems. It requires some public-private partnership, and I think that some of the proposals that will be in this package that you'll be receiving address that issue. And it requires, I think, better work by everybody involved.
Well, we look forward to the package and to the package that you'll be receiving in hopefully a very short time. Thank you.
Thank you, Senator, and I want to thank Ms. Rich and Mr. Weinstein. Mr. Weinstein, good luck and congratulations with your new baby. We will now proceed to the second panel of this hearing. I think I'll introduce our panel as they're making their transition to the table, just to move things along. Well, maybe seems to be a little chaos here. We'll take a little moment of pause to think about the first panel and all the issues that were raised and thoughts that were expressed.
That are not like issues that maybe they're out of the mainstream, but they're very, very important, and we're just realizing just how important they are to cover.
All right, now I'd like to introduce our second panel of witnesses, and I want to thank you all for being here. Ashkan Sultani is a technology researcher and consultant specializing in consumer privacy and security on the Internet. He has more than 15 years of experience as a technical consultant to Internet companies and federal government agencies. Most recently, he worked as the technical consultant on the Wall Street Journal's What They Know series, investigating digital privacy issues. He has a master's degree in information science from the University of California at Berkeley and a BA in cognitive and computer science from the University of California, San Diego. Justin Brookman is the director of the Project on Consumer Privacy at the Center for Democracy and Technology. He was also the chief of the Internet Bureau of the New York Attorney General's office. Under his leadership, the Internet Bureau is one of the most active and aggressive law enforcement groups working on Internet issues. He received his JD from the New York University School of Law in 1998 and his BA in Government and Foreign Affairs from the University of Virginia in 1995. Dr. Bud Tribble is the Vice President of Software Technology at Apple. Tribble helped design the operating system for Mac computers. He was also the Chief Technology Officer for the Sun Netscape Alliance. Tribble earned a BA in Physics at the University of California, San Diego, and an MD and PhD in Biophysics and Physiology at the University of Washington, Seattle. Alan Davidson is the Director of Public Policy for the Americas at Google. He was previously Associate Director for the Center for Democracy and Technology and a computer scientist working at Booz Allen and Hamilton, where he helped design information systems for NASA's space station Freedom. He has an SB in Mathematics and Computer Science and an SM in Technology and Policy from MIT and a JD from Yale Law School. Jonathan Zook is the president of the Association for Competitive Technology. ACT represents small and mid-sized information technology companies. Before joining ACT, Zook, or is it Zuck or Zook? Zook, good, I got it right. Zook spent 15 years as a professional software developer and an IT executive. He holds a BS from Johns Hopkins University and a master's in international relations from the Paul H. Nitze School of Advanced International Studies at the Johns Hopkins University. I want to thank you all for being here today. And please give your opening statements. We'll start from my left and your right, Mr. Soltani.
Chairman Franken, Ranking Member Coburn, and distinguished members of the subcommittee, thank you for the opportunity to testify today about mobile privacy and the location ecosystem. My name is Ashkan Soltani. I'm a technology researcher and consultant specializing in privacy and security on the internet. I should note the opinions here are my own and don't reflect the views of my previous employers. Mobile devices today are powerful computing machines, but unlike desktop computers, mobile devices introduce unique privacy challenges. Consumers carry their phones and tablets with them nearly everywhere they go, from their homes to their offices, from daycare to the grocery store. A device's location can be determined using a number of different technologies, including GPS, information about nearby cell towers and Wi-Fi access points, and other network-based techniques. While the accuracy can vary depending on the technology being used, the resulting insights derived from this data can be sensitive and personal in nearly all the cases. If you imagine a historical trail of your whereabouts over the course of many days, it would be reasonably easier to deduce where you work, where you live, and where you play. This information can reveal much about who you are as a person and how you spend your time. I believe this is why many consumers have been surprised by the recent stories of how their mobile devices have been collecting their location information and other sensitive data. With the exception of GPS, the process by which a device's location is determined can actually expose the location of that device to multiple parties. These parties include the wireless carrier, for example, AT&T and Verizon, the location service provider, such as Apple, Google, or Skyhook, and even the content provider used to deliver the information about that location, such as a mapping website or service. Researchers, including myself, recently confirmed that smartphones, such as the Apple iPhones and Google Android devices, send location information quietly in the background to Apple and Google servers, respectively, even when the device is not actively being used. That is, the background collection happens automatically unless the user is made aware of the practice and elects to turn it off. This is the default behavior when you purchase these devices. Furthermore, most smartphones keep a copy of historical location information directly on the device. Until recently, Apple's iPhone would retain an approximate log of your location history for about a year, stored insecurely on the phone and on any device the computer was backed up to. Anyone with access to this file would be able to obtain a historical record of your approximate location, and there was no way to disable it. Many mobile smartphone platforms, like Apple's iOS and Google Android, also allow third parties to develop applications for the device. Productivity software like email, social networking tools like Facebook, and of course, games. As reported in the Wall Street Journal last year, many popular apps transmit location information or its unique identifiers to outside parties. For instance, if a user opens Yelp, a popular restaurant discovery app, not only does Yelp learn information about the user, but so could Yelp's downstream advertising and analytics partners. This may be surprising to most customers, since they may not have an explicit relationship with these downstream partners. This information isn't limited to just location. Upon installation, many of these apps would have access to a user's phone number, address book, and even text messages. Disclosure about the collection and use of consumer information are often ineffective or at times completely absent. Many disclosures are often vague or too confusing for the average consumer to understand, and they rarely mention specifics about data retention and information sharing practices, things that a privacy-conscious consumer would care about. Notably, near half of the popular apps analyzed by the Wall Street Journal lack discernible privacy policies. To conclude, in order to make meaningful choices about their privacy, consumers need to increase transparency into who's collecting information about them and why. Clear definitions should be required for sensitive categories of information, such as location and other identifiable information. Software developers need to provide consumers with meaningful choice and effective opt-outs that allow consumers to control who they share information and for what purpose. Only in an environment that fosters trust and control will consumers be able to take full advantage of all the benefits of mobile technologies have to offer. I thank the committee for inviting me here today to testify, and I look forward to answering your questions.
This piece to it.
Thank you, Mr. Brooker.
Thank you very much, Chairman Franken, Ranking Member Coburn, members of the subcommittee. Thank you very much for the opportunity to testify here today. There really could not be a more timely topic for the first hearing of the subcommittee than the issue of mobile privacy. Consumers are enthusiastically embracing mobile devices, and they offer an amazing array of functionality that truly makes our lives better. However, many of the same privacy issues that have frustrated consumers in the online space are actually significantly heightened in the mobile environment. As opposed to websites, apps can access a far broader range of personal information, such as contact information, access to a smartphone's camera or microphone, and precise geolocation information. At the same time, the tools that consumers have to see and control how apps share their personal information are actually weaker than they are on the web. And I've been invited here today to discuss the existing laws that govern mobile data flows and whether that framework has proven adequate to safeguard consumer information. And the short answer is no. There is no comprehensive privacy law in the United States. There are a few sector-specific laws that govern relatively small sets of consumer information. In the mobile space, I think it's fair to say that there is a patchwork of outdated and inapt laws that may apply at the margins but do not offer consumers meaningful and consistent protections. Now, traditionally, mobile devices were one area where there actually were strong protections over consumer data. The Communications Act and the associated CP&I rules historically required carriers to give customers affirmative permission to share or sell the relatively limited information around the traditional dumb phones, which is who you can call and whatnot. However, as cell carriers branched out into offering data plans for smartphones, the FCC opted not to extend CP&I rules to those information services, leaving the treatment of customer information about this new usage of mobile services unregulated. Furthermore, CP&I rules never applied to most of the players in the modern app space, such as operating system and location providers like Apple and Google, apps makers, mobile advertising networks, and data brokers. So as the mobile data ecosystem has dramatically expanded, the relatively narrow CP&I rules, which at one point effectively covered everything, no longer offer sufficient protections for consumers in the mobile space. There are a couple other statutes that arguably apply at the margins, but they do not consistently protect consumers here. So one would be the Electronic Communications Privacy Act, which we discussed, which generally covers government access to information, but does have some protections around certain companies from disclosing the content of customer communications. Unfortunately, the definitions of this law were written in 1986, well before the modern apps ecosystem developed. The law could arguably be interpreted to cover some apps, but certainly not all, and probably doesn't extend to the operating systems like Apple and Google. In short, the law does not really map well to mobile privacy issues, and certainly not consistently. And even if it did apply to all the players, without additional rules to require meaningful transparency and telling consumers what you're doing with their data, companies could just bury permissions to share data in terms of service agreements that consumers would be unlikely to read. Finally, some have tried to apply criminal statutes like the Computer Fraud and Abuse Act to mobile privacy issues. Last month, for example, it was reported that the U.S. Attorney from New Jersey was investigating certain apps for transmitting customer information without adequate disclosure. And I think I'm sympathetic to the policy goals of requiring better disclosure from apps, I think it's probably not the ideal approach to use a very broad criminal statute designed to combat hacking and protect financial information to protect privacy. I may not like it when companies share my information, and I think that should be protected by the law. I don't think people should necessarily go to jail for it. So assuming that none of these diverse laws actually apply, the baseline in this country is set by the FTC's prohibition on unfair and deceptive practices. The FTC has brought some incredibly important cases in this area, but the bar is still very low. The baseline rule for most consumer data is merely that companies cannot affirmatively lie about how they're treating your data. So many companies' response might just be not to make any representations at all. This is why privacy policies tend to be legalistic and vague. The easiest way for a company to get in trouble is to actually make a concrete statement about what they're doing. Indeed, in the mobile space, as Mr. Soltani testified, many app makers don't make representations at all. Only a small percentage actually offer any privacy policies whatsoever. And so it's just not possible in the modern environment for people to figure out how their data is being stored by apps and shared. So we've long petitioned for a baseline comprehensive privacy law that requires companies to say what they're doing with data, to give some choice around secondary transfers of that data and secondary uses, and tell companies to get rid of it when they're done. Furthermore, for sensitive information, stuff relating to religion or sexuality, health, financial, and most relevant to this hearing, precise geolocation information, we believe that an enhanced application of the Fair Information Practice principles, including affirmative opt-in consent, should govern. For this type of information, we should err on the side of user privacy and against presuming assent to disclosure. Thank you very much for the opportunity to testify, and look forward to your questions.
Thank you, Mr. Brookman. And by the way, for all of you, your complete written testimonies will be made part of the record. Mr. Tribble.
Good morning, Chairman Franken, Ranking Member Coburn, and members of the subcommittee. My name is Bud Tribble. I'm Vice President for Software Technology for Apple. Thank you for the opportunity to further explain Apple's approach to mobile privacy, especially location privacy. I'd like to use my limited time to emphasize a few key points. First, Apple is deeply committed to protecting the privacy of all of our customers. We've adopted a single comprehensive customer privacy policy for all of our products. This policy is available from a link on every page of Apple's website. We do not share personally identifiable information with third parties for their marketing purposes without our customers' explicit consent. And we require all third-party application developers to agree to specific restrictions protecting our customers' privacy. Second, Apple does not track users' locations. Apple has never done so and has no plans to ever do so. Our customers want and expect their mobile devices to be able to quickly and reliably determine their current locations for specific activities such as shopping, travel, or finding the nearest restaurant. Calculating a phone's location using just GPS satellite can take up to several minutes. iPhone can reduce this time to just a few seconds by using pre-stored Wi-Fi hotspot and cell tower location data on the phone in combination with information about which hotspots and cell towers are currently receivable by the iPhone. In order to accomplish this goal, Apple maintains a secure crowdsourced database containing information with known locations of cell towers and Wi-Fi hotspots that Apple collects from millions of devices. It's important to point out that during this collection process, an Apple device does not transmit to Apple any data that is uniquely associated with the device or with that customer. This information is used to determine the locations of cell towers and Wi-Fi hotspots for our crowdsourced database. Third, by design, Apple gives customers control over collection and use of location data on all our devices. Apple has built a master location services switch into our iOS mobile operating system that makes it extremely easy to opt out entirely of location-based services. The user simply switches the location services off in the settings screen. When the switch is turned off, the device will not collect or transmit location information. Equally important, Apple does not allow any application to receive device location information without first receiving the user's explicit consent through a simple pop-up dialog box. The dialog box is mandatory and cannot be overridden. Customers may change their mind and opt out of location services for individual applications at any time by simple on-off switches. Parents can also use controls to password protect and prevent access by their children to location services. Fourth, Apple remains committed to responding promptly and deliberately to all privacy and technology concerns that may arise. In recent weeks, there has been considerable attention given to the manner in which our devices store and use a cached subset of Apple's anonymized crowdsourced database. The purpose of this cache is to allow the device to more quickly and reliably determine a user's location. These concerns are addressed in detail in my written testimony. I want you to reassure you that Apple was never tracking an individual's actual location from the information residing in that cache. Furthermore, the location data that was seen on the iPhone was not the past or present location of the iPhone, but rather the location of Wi-Fi hotspots and cell towers surrounding the iPhone's location. Apple did not have access to the cache on any individual user's phone at any time. Although the cache was not encrypted, it was protected from access by other apps on the phone. Moreover, the cached location information was backed up on a customer computer. It may or may not have been encrypted, depending on what the user settings were. While we were investigating the cache, we found a bug that caused this cache to be updated from Apple's crowdsourced database even when the location services switch had been turned off. This bug was fixed, and other issues, including the size and the backup of the cache, have been addressed in our latest free iOS software update released last week. In addition, in our next major iOS software release, the location information stored in the device's local cache will be encrypted. In closing, let me state again that Apple is strongly committed to giving our customers clear and transparent notice, choice, and control over their information, and we believe our products do so in a simple and elegant way. We share the subcommittee's concern about the collection and misuse of any customer data, particularly location data, and appreciate this opportunity to explain our approach. I'd be happy to answer any questions you may have.
Thank you, Mr. Tribble. Mr. Davis.
Thank you, Chairman Franken, Ranking Member Coburn, and members of the subcommittee. My name is Alan Davidson, and I am the Director of Public Policy for Google in North and South America. Thank you for this opportunity to testify at this important hearing before this new subcommittee. Mobile devices and location services are now used routinely by tens of millions of Americans and create enormous benefits for our society. Those services will not be used, and they cannot succeed without consumer trust. That trust must be built on a sustained effort by our industry to protect user privacy and security. With this in mind, at Google, we have made our mobile location services opt-in only, treating this information with the highest degree of care. Google focuses on privacy protection throughout the life cycle of a product, starting with the initial design. This is the privacy by design concept that was discussed at the last panel. We subscribe to the view that by focusing on the user, all else will follow. We use information where we can provide value to our users, and we apply the principles of transparency, control, and security. We are particularly sensitive when it comes to location information. As a start, on our Android mobile platform, all location sharing for Google services is opt-in. Here's how it works. When I first took my Android phone out of its box, one of the initial screens I saw asked me, in plain language, to affirmatively choose whether or not to share location information with Google. A screenshot of this process is included in our testimony and on the board over here. If the user doesn't choose to turn it on at setup, or doesn't go into their settings later to turn it on, the phone will not send any information back to Google's location servers. If they opt in, the user opts in, all location data that is sent back to Google's location servers is anonymized and is not traceable to a specific user or device, and users can later change their mind and turn it off. Beyond this, we require every third-party application to notify users that it will be accessing location information before the user installs the app. The user has the opportunity to cancel the installation if they don't want information collected. We believe that this approach is essential for location services. Highly transparent information for users about what is being collected, opt-in choice before the location information is collected, and high security standards to anonymize and protect information. Our hope is that this becomes a standard for the broader industry. We are doing all this because of our belief in the importance of location-based services. Many of you are already experiencing the benefits of these services, things as simple as seeing real-time traffic, transit maps to aid your commute, finding the closest gas station on your car's GPS. And it's not just about convenience. These services can be lifesavers. Mobile location services can help you find the nearest hospital or police station. They can let you know where to fill a prescription at 1 in the morning for a sick child. And we've only scratched the surface of what is possible. For example, Google is working with the National Center for Missing and Exploited Children to explore how to deliver Amber Alerts about missing children to those in the vicinity of the alert. And mobile services may soon be able to tell people in the path of a tornado or tsunami, or guide them in an evacuation route in the event of a hurricane. These promising new services will not develop without consumer trust. The strong privacy and security practices that I've described are a start. But there are several privacy issues that require the attention of government, problems industry can't solve on its own. As a start, we support the idea of comprehensive privacy legislation that could provide a basic framework to protect consumers online and offline. And we support action to improve data breach notification instead of the current confusing patchwork of state laws that exist. And a critical area for Congress, and particularly for this committee, is the issue of government access to a user's sensitive information. We live now under a 25-year-old surveillance law, ECLA, first written before webmail or text messaging was even invented. Most Americans don't understand that data stored online doesn't receive the Fourth Amendment protections given to that same information on a desktop. Nor do users know that the detailed location information collected by their wireless carrier can be obtained without a warrant. Google is a founding member of the Digital Due Process Coalition, a group of companies and public interest groups seeking to update these laws to meet the needs and expectations of 21st century consumers. We hope you will review its work. And in summary, I'll just say we strongly support your involvement in this issue. We appreciate the chance to be here. We look forward to working with you to build consumer trust in these innovative new services. Thank you.
Thank you very much, Mr. Davidson. Mr. Zook.
Chairman Franken, Ranking Member Coburn, and distinguished members of the subcommittee, my name is Jonathan Zook, and I'm the president of the Association for Competitive Technology, and I want to thank you for holding this important hearing on privacy in the emerging mobile marketplace. As a representative of more than 3,000 small and medium-sized IT companies, a former software developer myself, and the spokesman for the people that write the applications for these mobile devices, I want to encourage you to treat the issue of privacy generally and of the mobile marketplace specifically in a holistic manner. The science of holistic processing is really known best for faces, where we are able to recognize an entire face and not just see it as a nose, 2 eyes, and a mouth. You only need to watch a television commercial for a mobile device, such as an iPod or a Zoom or a Droid phone, to understand that the face of mobile computing is the applications. These ads showcase the more than hundreds of thousands of applications that are available for these devices, some of which we've already heard about in previous testimony today, that allow you to find out where you are, to find services and products that are close to you, etc. These are exciting and dynamic applications that have been made available to users and that many users are using today. Location-based services and advertising offer a unique opportunity for Main Street businesses as well. A user searching for a particular product or service on their smartphone can receive an ad from a local small business based on their current location data. These ads have the benefit of reaching potential customers at the exact time a purchasing decision is being made for a much smaller cost than the newspaper circulars or TV ads that big box stores are able to afford. This dynamic market, valued today at about $4 billion, is projected to be the size of $38 billion by 2015. Application developers are enjoying a kind of renaissance brought by the lower cost to entry and the distribution and are often consumer-facing applications. These applications we've all come to enjoy are made predominantly by small businesses. Over 85% of them are made by small businesses, and not just in Silicon Valley. The next time, Chairman Franken, you're drawing one of your famous maps, you'll be able to reflect that over 70% of these applications come from outside of California, including in places such as Moorhead, Minnesota, and Tulsa, Oklahoma. This is a national phenomenon with international implications for economic growth and recovery. We have an opportunity to meet the President's goals to double exports. We're at a period of rapid experimentation and delivery of new services with a complete focus on the customer. One benefit of small businesses taking the lead here is that they cannot afford to ignore the demands of their customers. Second, when approaching the issue of data privacy in a holistic manner, I think it's imperative, as we heard from the earlier panel, to remember that there's a whole lot of data. To focus on a particular new type of data collection is to truly cut off our nose to spite our face. There's more data, including location data, in large company databases than the top 1,000 mobile applications could hope to collect in a lifetime. In fact, to focus on a particular type of data collection in a particularly new market would necessarily discriminate against the small businesses that are responsible for so much economic growth in the mobile sector, while leaving larger players largely untouched. Finally, there are myriad laws in place to address legitimate privacy and consumer protection concerns, as was raised earlier. Whether it's fair trade practices at the state or federal level, there are vehicles in place to address transgressions. Even the use of antitrust has been used in the past to deal with privacy issues. While I don't agree with all of the recommendations made by the Center for Democracy and Technology, I would agree that any approach to privacy legislation needs to be comprehensive and should focus on the data itself and how it's used and answer these general questions and not focus on a particular means of collection or particular technology platform. There is legitimate concern among American consumers about their privacy. As we heard from Chairman Leahy, a number of Americans are concerned about their privacy. I think one of the ongoing frustrations of my constituents and of small businesses in general is that they find themselves time and time again doing the time without really having done the crime. It's as though once a week there's some kind of a big company news, like the Sony PlayStation debacle, Epsilon's data loss, and Google with Spy-Fi collecting children's social security numbers and Buzz. These are the issues that are really causing the concern and fear among customers, not the prospect of getting one more customized ad to their phone. Despite that fact, the rules that get created inevitably impact small businesses more than our larger brethren. The Google Buzz settlement is a good example of this phenomenon. The FTC has stated it would like to use the Google Buzz settlement as a model for regulation going forward for the entire industry. The true irony is that not only have Google brought this regulation to our doorstep, the level of vertical integration they enjoy makes them immune to most of the consequences. Who's most likely to be affected by a law that affects the transfer of information to third parties? A small business that has to form partnerships in order to provide these services in an ever-changing marketplace, or a huge company that can simply buy the third party, thereby circumventing the rule? The idea of holism dates back to Aristotle, who was the first to say the whole is more than the sum of its parts. And nowhere is that more true than in the mobile computing marketplace. Accordingly, I'd like to encourage members of this committee to take a step back from the headlines of today and look at the issue of privacy in a holistic manner. Thank you, and I look forward to your questions.
Thank you, Mr. Zook, and thank you all for being here today and for your thoughtful testimony. Mr. Tribble, last month I asked Apple in a letter why it was building a comprehensive location database on iPhones and iPads and storing it on people's computers when they sync up, of course. Apple's reply to my letter will be added to the record. But this is what Apple CEO Steve Jobs said to the press, quote, "We build a crowdsourced database of Wi-Fi and cell tower hotspots, but those can be over 100 miles away from where you are. Those are not telling you anything about your location," end quote. Yet in a written statement issued that same week, Apple explained that this very same data will, quote, "help your iPhone rapidly and accurately calculate its location." Or as the Associated Press summarized it, the data helped the phone figure out its location, Apple said. But Steve Jobs the same week said, those are not telling you anything about your location. Mr. Tribble, it doesn't appear to me that both of these statements could be true at the same time. Does this data, I understand you're anticipating my question, so I'll just ask it and then you'll answer. Does this data indicate anything about your location or doesn't it?
Senator, the data that's stored in the database is the location of as many Wi-Fi hotspots and cell phone towers as we can have. That data does not actually contain in our databases any customer information at all. It's completely anonymous. It's only about the cell phone towers and the Wi-Fi hotspots. However, when a portion of that database is downloaded onto your phone also knows which hotspots and cell phone towers it can receive right now. So the combination of the database of where are those towers and hotspots, plus your phone knowing which ones it can receive right now, is how the phone figures out where it is without the GPS.
Okay, Mr. Sultana, consumers are hearing this a lot from both Apple and Google, and I think it's confusing. Because Apple basically said, yes, that file has location, but it's not your location. And when it separately came out that both iPhones and Android phones were also automatically sending certain location data to Apple and Google, they both said, yes, we're getting location, but it's not your location. Mr. Sultani, tell me, whose location is it? Is it accurate? Is it anonymous? Can it be tied back to individual users?
Thank you, Senator. I think that's a great question. So yeah, in many cases, the location that this data refers to is actually the location of your device or somewhere near it. While it's true that in some rural areas, this can be up to 100 miles away, in practice for the average customer or the average consumer, it's actually much closer, in the order of about 100 feet, according to a developer of this technology, Skyhook. If you refer to Figure 3 of my testimony, you can see an example of this location as identified by one of these Wi-Fi geolocation databases. I took my location based on GPS and my location based on the strongest nearby Wi-Fi signal in the Senate lobby, just out here. And the dot on the left refers to my location as determined by exact GPS, and then the dot on the right determines my location based on this Wi-Fi geolocation technology, and it was about 20 feet from where I was sitting on the bench. So, depending on how you want to slice it, I would consider that my location. In the files in these databases will contain timestamps that describe at what point I encountered some of these Wi-Fi access points, so they could be used to trace a kind of a trail about you. And then finally, to the degree that this data contains identifiers that's sent back, so IP addresses. We heard earlier that the gentleman from the DOJ, he was claiming that IP addresses are necessary to identify consumers or criminals. To the degree that those IP addresses are used to identify criminals, they become identifiable, and it's really difficult to call this stuff anonymous. Making those claims, I think, is not really sincere.
Well, because basically, if you have, this location, like in your illustration, you see that you're in the Hart Building.
Or near the entrance of the...
Yeah. And so, well, let me ask Mr. Brooklyn the same question I asked Mr. Weinstein. My wireless company, companies like Apple and Google and the mobile apps I have on my phone all can and do get my location or something very close to it. And my understanding, Mr. Brooklyn, is that in a variety of cases under current law, each of those entities may be free to disclose my location to almost anyone they want to without my knowing it and without my consent. Is that right? And if so, how exactly can they do this?
I think that is correct. So, as I mentioned before, the default law in this country for sharing of data is you can do whatever you want. Right? The only thing you can't do is what you've previously promised not to do with that data. So, if someone like Apple or Google said, "Hey, if you give this location data to Google Maps, we promise not to share it with an advertising partner." Under that scenario, they would be prohibited under the FTC Act from sharing it. Otherwise, I think for the most players in this space, I think it would be very hard to make a legal argument that they were required to have the affirmative requirement not to share data.
Thank you. Mr. Davidson, Mr. Tribble, my let me ask you one last question because my time is running out. Your two companies run the biggest app markets in the world, and both of your companies say you care deeply about privacy. And yet, neither of your stores requires that apps have a privacy policy. Would your companies be willing to commit to requiring apps in your stores to have a clear, understandable privacy policy? This would by no means fix everything, but it would be a simple first step and would show your commitment on this issue. Mr. Davidson?
It's a great question. I would be happy to take it back. I think is an extremely important issue that you raise about application privacy. At Google, we have tried to maximize the openness of our platform to allow lots of different small businesses to develop applications. We have relied on a permissions-based model at Google so that before an application could get access to information, they have to ask permission from the user. You're asking about the next step, which is whether we put affirmative requirements on applications. And I would just say I will take that issue back to our leadership. I think it's a very good suggestion for us to think about.
Mr. Tribble?
Yeah, I think that's a great question. What we do currently is we require contractually third-party app developers to provide clear and complete notice if they're going to do anything with the user's information or device information. So if you want to become an Apple developer and put an app in the App Store, you sign an agreement with Apple that says you're going to do that. Now, it doesn't specifically require a privacy policy, but what I'll say is that probably a privacy policy in this general area is not enough. And I agree with the earlier panel that what we need to do, because people may not read a privacy policy, is put things in the user interface that make it clear to people what is happening with their information. And Apple thinks this way. For example, when an app is using your location data, we put a little purple icon right up next to the battery to let the user know that. Now, we say that in the privacy policy too, and the app should say that too, but we also put something in the user interface to make it even more clear to the user. We also have an arrow that shows if an app's used your location in the last 24 hours. So transparency here goes beyond just what's in the privacy policy. It's designing into the app and the system itself information, feedback to the user about what's happening with their information.
Okay, thank you. Just one yes or no, Mr. Soltani. Isn't it true that there is no mechanism for iPhones to notify users that their apps can disclose their information to whomever they want? Okay, thank you.
It's true.
Thank you. Senator Coburn.
Let me defer to Senator Blumenthal. I have a meeting that I have to take for about 5 minutes, and then I'll be back in.
Senator Blumenthal.
Thank you, Mr. Chairman. Thank you, Senator Coburn. I want to focus on really the very broad area or issue of trust that Mr. Davidson raised, which I think goes to the core of much of what you do with the consent and acquiescence of consumers, and most particularly the practice and goal of building wireless network maps. Both Apple and Google are engaged in that business activity, are you not?
Yes.
Yes.
And in particular, Mr. Davidson, I want to ask some questions about the Google Y-Spy experience, scandal, debacle. All three terms have been used to refer to it. In particular, as you well know, and now we all know, for 3 years, Google intercepted and collected bits of user information, payload data, emails, passwords, browsing history, and other personal information while driving around taking pictures of people's homes on the streets in the Street View program. The company first denied that it was collecting this information, did it not?
It did. We did not believe that we were. We did not know that we were.
And then it denied that it was collecting it intentionally. Is that true?
I think we still believe we were not collecting it intentionally.
And in fact, this personal data and the interception and downloading of this personal data is contemplated, in fact, by a patent application that's been submitted by Google to both the U.S. Patent Office and internationally. Does it not?
I'm not specifically familiar with the details of the patent application.
I think you've been provided with a copy.
Is that what this is here?
Maybe you could have a look at it.
Okay.
Do you recognize the document? Have you seen it before?
I have not seen this document before, but I'm probably roughly, I have not seen this document before.
Are you familiar with the goal that it describes of, in fact, pinpointing the locations of wireless routers to construct a wireless network map by intercepting and downloading the payload data in precisely the way that Google denies having done?
No, I'm not. I apologize. I am not familiar with that aspect of this, or really anything relating that to this patent to content, to the content of payload.
Are you aware that this process may have been used in the Street View program to collect private confidential information and use it to construct the wireless network route?
That would be. I would be very surprised. I think we have tried to be very clear about the fact that it was not our policy to collect this information. It was not the company's intent to collect the content or payload information. I think we've been very specific about the fact that we never used that information. As you indicated, people at the company were quite surprised and honestly embarrassed to find out that we had been collecting it. So this, we've said before, this was a mistake, that we did not intend to collect this information, and we've tried very hard to work with regulators to make sure we're now doing the responsible thing. We haven't used it, and we are working with regulators around the world to figure out what to do with it, and in many cases we've destroyed it.
Why would the company then submit a patent application for the process, that very process that it denies having used?
And I'm sorry I can't speak to the specifics of this patent. We were not aware that this was a topic for today's hearing, but I will say generally we submit patent applications for many, many different things. Often they are fairly speculative. We probably do, I don't know, hundreds of patent applications a year, certainly scores. And it would not be surprising at all that in this area that is so important, we would be looking for innovative ways to provide location-based services. But it was certainly, as we have said publicly, it was a mistake, and we certainly never intended to collect payload information.
Well, in fact, the payload information would be extremely valuable in constructing this wireless network map, would it not?
I'm not sure that we would say that. I think that what's most important is basically having the identification of a hotspot and a location, which is what we were collecting, and that's what we've used to create this kind of database, as others have. And it's not obvious that small snippets of a few seconds of whatever happens to be broadcast in the clear from somebody's home at any given precise second when you're passing by with a car would necessarily be that valuable, and I think we certainly never intended to collect it.
Would it be valuable, in your opinion, Mr. Tribble, to have that kind of payload data in constructing a wireless network map?
I'm actually not sure how valuable.
Get your mic on.
Right. Yes, Senator. I'm actually not sure how valuable it would be. We don't collect that or use that in our mechanisms for geolocating. In fact, I checked with the engineering group, and they said they're not sure how you would do that, but they probably haven't seen the patent. So I can't really, I guess, specifically answer your question.
Let me ask Mr. Brookman and Mr. Soltani whether you have an opinion as to whether payload data would be useful in strengthening the location network or map.
I'm not a technologist, so I'll mostly defer to Mr. Soltani. My instinct is that I don't think that it would be. The primarily interesting fact is that here is a wireless access point. They may need to sense that it's sending information out technologically, but I don't believe that the content of that communication would be valuable at all.
I would concur with Justin. I think the small differentiation is, what you're referring to is whether the header information, which is not necessarily, there's a question of whether that's payload data. So Google collects the information about the hotspot, which includes the header information about the MAC address or the identifier for that hotspot. And I think that's the question of whether that's payload data. I would feel like it's also not payload data, but that remains to be determined by others.
Let me turn back then to Mr. Davison. What are the plans that Google has to use or dispose of the information that has been downloaded and collected?
So we are in active conversation with many regulators, including your former office in the state of Connecticut, but regulators around the world. Some of them have asked us to destroy the data, and we've done so. Some of them are continuing their investigations. Our intent is to answer all the questions of any regulator who's got an interest in this fully. We do not intend to ever use this data. We intend to dispose of it in whatever form regulators tell us we should.
And would you agree that collection of this data violates privacy rights and that it may in fact be illegal?
I think our position was that was not illegal, but it was not our intent either, and it wasn't how we expect to operate our services.
If it was not illegal, don't you agree it should be?
I think this raises a really complicated question about what happens to things that get broadcast in the clear and what the obligations are about people hearing them. And I think it's a complicated question. It's an important question, but I think we'd have to be careful about it. I think the law appropriately says regulates, I believe it regulates the use of that information. And as I've said before, we have no intention to use it.
I will have additional questions, Mr. Chairman. My time has expired, and I appreciate your indulgence. In the meantime, I'd like these patents to be made a part of the record.
Absolutely. The ranking member.
Thank you, Mr. Chairman. This is for both Apple and Google. You both have requirements for the people that supply apps for your systems. How do you enforce the requirements that you place on them? Specifically, how do you know that they're keeping their word? How do you know they're not using data different than what they have agreed to? How do you know they're not tracking?
Yes, Senator. So Apple curates the apps that are in our store. The way people get apps onto their phone is that they're in the Apple App Store. As I mentioned, we have requirements for the app developers. What we do is we examine apps, look at them. We don't look at their source code, but we run them, we try them out, we examine them before we even put them into the App Store. If they don't meet our requirements,
I understand that, but
yes.
Once they're in your App Store...
Once they're in the App Store, we do random audits on applications. Now, we have 350,000 apps. We don't audit every single one, just like the federal government doesn't audit every single tax return. But we do random audits and do things like examine the network traffic produced by that application to see if it's properly respecting the privacy of our customers. If we find an issue through that means or through public informations, a blog, or a very active community of app users, we will investigate. And if we find a violation of our terms, including privacy terms or specific location handling terms, we will contact, we'll contact them during the investigation and hopefully gotten them to fix it. But if they don't, we will notify them that their app will be removed from the store within 24 hours, and we will do that. Now, in fact, the overwhelming common case is that the app developers are highly incented to stay in the App Store. So during the investigation, or if we warn them, typically they correct. And often that correction involves making sure they pop up a notice panel telling the customers what they're doing.
Mr. Davis.
So we have taken a slightly different approach at Google. We've really strived to make sure that our platform is as open as possible. And we've chosen not to try to be a gatekeeper in terms of what applications people get access to. That is striking a balance, but we have tried to maximize openness, and we've taken a different approach to try to protect consumer privacy, which is to use the power of the device itself to make sure that people know what information is being selected. And so the device itself will tell you when you want to install an application what that application wants to have access to. And that, we believe, is a very powerful form of policing for users. But we don't then generally go back and try to make sure that every application does what it says it's going to do, because we have, as I say, a large number, but we're also really trying to maximize the ability of small app developers to get online.
Is that notification when you download that app in plain English where it's easily understood, or is it a 10-page deal that everybody scrolls down to and says, I accept?
It is a terrific question. We have tried really hard to avoid that. So we do not show that 10-page thing that the lawyers write that says all the different things that may happen. It is plain language. It is rarely more than a screen. Sometimes you have to scroll down a little bit. And it says very specifically what pieces of information, not just location information, all types of information that might be coming from the phone that application has sought access to. And I'll tell you personally, I've seen applications that I've rejected, and I think hopefully a lot of people do this when you say, well, why does my solitaire program need my contact database? It doesn't, and I should reject it.
What is the motivation for the app producer? And Mr. Zuck, you can comment on this too, to have that information. Is it so they can reuse it and sell it?
I'm sure that it's going to be a combination of things, and I'm sure that in many cases they will be providing valuable services. Foursquare or other location services will help let you know where if your friends are nearby. Twitter lets you look at tweets that are near your location. There are really valuable services out there that are going to be provided. Sometimes people might be using data to serve ads better or to build a database of their own, and that's the kind of thing I think consumers need to decide whether they want to make that trade.
Mr. Tribble, do you want to comment on that?
I think that there are a variety of reasons why third-party apps would want that kind of information, and a variety of things that they would do with it. Again, what we require the apps to do is to tell the users before they do that, let them have a way of choosing not to do it or to change their mind later. So it's an area where there's a lot of innovation. I'm sure Mr. Zook can tell you about that. And it's an important area in terms of privacy and rapidly evolving.
Thank you, Senator. It's a very good question, and it's exciting here at the kids' table to be heard and not just seen, I suppose. Most of the privacy policies of these small businesses reflect the fact that most of these businesses are not collecting personal information. And those that are, very often, their privacy policies extend from their other online presences or websites, et cetera. And as to your question about the use and why they do it, most of the time it's some overt process where someone is actively checking in or doing something very specific where they know they're sharing information in order to get information. But the other use of the information is to allow for partnerships and revenue streams from ad networks. And so data isn't stored by these small businesses in most cases, but actually transferred back to the likes of Google and Apple that are the ones that are actually accumulating the large databases of data about these users. The one thing that's worth noting, though, is that is another bite at the apple that these folks have with application developers, and that there's terms of services for those ad networks as well. So that in sharing the information back to Apple or Google, there are restrictions on the kind of policies we have to have in place in order to share that information back with that ad network and to make use of that service.
Thank you very much. I'll have additional questions of the record for Mr. Brookman and Mr. Soltani. Senator Whitehouse.
Thank you very It strikes me that we're in a very new area and trying to think about what our takeoff point should be. What existing models are a good analogy for where we are right now and where we should go is an interesting discussion to have, and I'd encourage each of you to take that as a question for the record, if you could, for me, and get back to me in writing, because it's a longer discussion than we have time for. But if you want to sell pharmaceuticals in this country, you can do so, but you have to disclose their side effects. If you want to operate on somebody in this country, you can do so, but you have to get their consent and list the things that could go wrong in the surgery. If you want to sell a consumer product in this country, you have to put appropriate warnings on, and if the product is dangerous, you've got to pull it back off the market. If you want to sell stock in this country, you've got to file a proper SEC filing so people know what the financial information behind the stock offering is, and they can make an intelligent decision. In all of those different ways that we regulate conduct, we're trying to make, to your statement, Mr. Davidson, as open as possible a market, but not at the expense of people who are trying to take advantage of people. And so it worries me that the principle, we hear it from you in terms of as open as possible. We also hear it from the ISPs in terms of don't blame us for what comes across the pipes, even if it's crawling with malware and is really putting our, even potentially our national security at risk. We're just providing a service. We just want anything to go through. And that's not an argument that we allow to stand in pharmaceuticals, in consumer products, in surgery, in really anywhere. We build an arena in which the market can work, but we make sure that the boundaries of the arena are the boundaries of safety. And I think we really need to be working on those boundaries. And I think that as open as possible is simply not an adequate standard to this task. As open as possible, yes, but within what controls. And I think that's the question that we have to be focusing on. And it's complicated by the fact that some of these things you want, and you're choosing them. Some of it rides along with that. I don't know how effective your program that allows you to check in and out, tell you what things it has access to is in terms of the real-life consumer. What does a 14-year-old loading an app know about all these choices? How informed is that choice? So I'm not sure that's a boundary that I'm perfectly comfortable with. Mr. Tribble mentioned that you could change your mind later in the Apple system if you saw something was going wrong. I'm not sure. Can you change your mind in yours? Or
absolutely. You can, as I mentioned in my written and oral, you can easily go back and change.
How do you get prompted to once you've loaded the app?
Well, you can remove the application very, very easily. You can also change your settings in terms of what, like for example, use of the location services that Google provides.
But you have to be aware of it.
Absolutely, there is.
So if you're not aware that somebody's selling your location information to somebody you're not interested in having it, you don't really get a second bite at that apple.
No, and I think this is a tremendously important area about the need to educate our consumers and users better, because we believe you're right that a lot of users don't understand all this. We've tried to make it very simple, and we've tried to strike the right balance. I don't think we don't say openness at all costs. What we've said is we're trying to maximize, I don't even know if maximize, or we're trying to increase openness.
Yes.
We try to create a very open platform, and it is a different approach. It's not no holds barred. We do have a content policy for our market, but I think the question is where is the appropriate way? Who are the appropriate actors to go after? We don't go after trucking companies because they happen to carry faulty goods. We go after the manufacturers of those goods, and I would just say we're trying to strike the right balance, and we also need to really educate consumers. That's why a hearing like this is honestly so important, because it does shed a lot of light, even as we try to give people information.
You do go after the trucking company if the company knew what it was carrying.
And I think this is...
Google's in a better position to know what is being carried as a professional company that specializes in, that has vast resources than a 17-year-old who's been told by his friend that this is a cool app to load. So I wouldn't be satisfied. I don't think that's a comfortable analogy either for you to rely on. The other thing that if somebody wants to take control of your computer and slave it to their botnet, they will try a lot of different ways to do it. And many of the ways in which they try this stuff will involve broadcast to thousands of people. And most people are careful enough to know better than to open the attachment or whatever. They're getting more sophisticated and they're starting to add more personal data, so it's getting harder and harder to sort that out. But ordinarily, you could have a success rate of only 1 in 1,000 and still be a pretty successful propagator of a botnet. And so it seems to me that there are some things for which even a very high failure rate is still not good. So even if 999 of 1,000 of your customers said, oof, I don't want them to do that, if somebody is putting these apps up not for the facial purpose, for the stated purpose, but because they've loaded a bunch of other stuff behind it that they want to use for an ulterior motive, what I called earlier a Trojan horse. You take it for one reason, but that's not really why they're doing business with you. That's just their way to get in the door and into your computer and begin to be able to take economic advantage of your information. It seems to me that there's some line that we want to draw that is an absolute line that says even if you really shouldn't be in a position where you're agreeing to this with as little information as you have, in the same way that you try to protect people from having their computers slaved to botnets by spam emails. So, again, I think we need to consider a little bit more sort of what our model is going to be here and then work off of that. And all I can say is that I have not yet heard a model here today that is convincing to me that it adequately protects both the Internet itself and the privacy interests. We've talked a lot about privacy, but frankly, it isn't just privacy that's at issue here. When somebody's in your computer with an application, there are a lot of other ways they can cause mischief. And it could be all the way to outright malware rather than just it could be something that is ultimately illegal, not just something that is immediately unwelcome. So anyway, I want to just thank Chairman Franken for having this hearing. I think it's been very interesting, very significant. I think it's an issue where we've got a lot of work to do ahead of us, and I want to appreciate the participation of all of you. You all bring different perspectives to this. I don't think anybody's perspective is yet ideal, but together and working hard on this, I think that we can get something accomplished that will make the Internet safer and make people less vulnerable as consumers to abuse, and make sure that it's clearer that you're getting what you pay for or what you load up when you choose to take on these applications. So much appreciation to the chairman for his leadership on this.
Thank you, Senator Whitehouse. By the way, I apologize to the witnesses. I had to step out for a meeting with on Minnesota flooding. Senator Schumer is stepped in, and
thank you.
Recognize you.
First, let me thank you, Mr. Chairman, for having this very important hearing, and there are so many different types of issues and questions that have come up because we're in this brave new world where information is available much more freely, and that creates new privacy concerns, and creating the balance is one of the most important things we can do at the beginning of this century. So I look forward to your leadership and the leadership of Senator Coburn as we try to balance the important benefits, and I think I'm so glad you've stepped into this place. I always tell people the Senate has so many different vacuums that, somebody who's interested can sort of step into, and this is a classic example. So thanks for your leadership, Al. I'm glad that the representatives, I have a particular area that I know some of you know I care about. There are a lot of these areas I care about, but they're going to talk on a couple today. Apple and Google have come here, and I thank you both for that. I want to ask about a slightly different aspect of balancing technology with public safety, and that is the smartphone applications that enable drunk driving. As you know, several weeks ago, a number of my colleagues and I, Senators Udall, Lautenberg, Reed, and I, wrote letters to your companies calling your attention to the dangerous apps that were being sold in your app stores and asking you to take immediately remove them. The apps we were talking about endanger public safety by allowing drunk drivers to avoid police checkpoints. I don't have to go into how bad drunk driving is in our country, and I just read those newspaper articles, particularly at prom time and Christmas time, of parents just looking so forlorn because they've lost a kid to drunk driving. Anyway, the DUIs that were popping up in stores were terrifying because they undermine drunk driving checkpoints. The apps, they have names like Buzzed and Fuzz Alert, and they're intended to notify drivers in real time when they approach police drunk driving checkpoints. There's only one purpose to these. We know what that is. And that is to allow drivers to avoid the checkpoints and avoid detection. People often think twice about drunk driving while drinking, because they know they could get stopped with all the consequences, and these apps enable them not to. We brought these to the attention of RIM. They pulled the app down. I was disappointed that Google and Apple haven't done the same, and I'd like to ask you how you can justify to sell apps that put the public at serious risk. I know you agree with me that drunk driving is a terrible hazard, right? And I know each of your companies has different reasons for not removing these apps, so I'd like to discuss them with you separately. First, Mr. Davidson, tell me your reasoning, why Google hasn't removed this kind of application.
Well, I'll start by saying we do take this issue very seriously, and we appreciate you raising it. As I actually just discussed with Senator Whitehouse, we have a policy that on our application store, our application market on our platform, where we do try to maintain openness of applications and maximize it. And we do have a set of content policies regarding our Android marketplace. And although we need to evaluate each application separately, applications that share information about sobriety checkpoints are not a violation of our content policy.
Let me ask you this. Would you allow an app that provided specific directions on how to cook methamphetamines? That doesn't explicitly violate your the terms of your service explicitly, but generates a public safety hazard.
I think it would be fairly fact specific. We do look at these things specifically. I think applications that are unlawful or that directly related to unlawful activity, I think we do take those down. Malware, we do take down. You're right, but we do have a fairly open policy about what we allow.
No one's disputing fairly open, and that's the motto of Google. And you're a company that has paid the price in a certain sense for those beliefs. So everyone respects the company. But my view is, even under your present terms, prohibiting illegal behavior, this app would fit. But why wouldn't you then change the app to include this, at least specifically, so it doesn't, I know if you had to draft generalized language, might be trouble, but why wouldn't you do that?
Again, I think we have a set of content policies. We try to keep them broad, and I will just say you raised what we think is an extremely important question. It's a question that we're actively discussing internally, and I will take this back and your concern back to our most senior leadership.
If you don't believe under your current rules that this would be prohibited, you would look at specifically, at least narrowly, but trying to eliminate this app.
Yes.
You agree it's a terrible thing. It's a bad thing.
It is. We agree it is a bad thing. I agree it is a bad thing.
Yeah, and it probably causes death.
Senator, I think this is an extremely important issue.
All right, let's go to Mr. Tribble. Tell me why you haven't. Different reasoning. That's why I'm doing it separately.
Well, Senator, I share your abhorrence of drunk driving. As a physician who's worked in an emergency room, I've seen firsthand the tragedy that can come about due to drunk driving. So we're in complete and utter agreement on that. Apple, in this case, it is carefully examining this situation. One of the things we found is that some of these applications are actually publishing data on when and where the checkpoints are that are published by the police departments.
No, not in the same time sequence.
In some cases, the police department actually publishes when and where they're going to have a checkpoint. Now that, not all of them do that, and there's variances to their theories on why they...
How many police departments do that?
I've seen a map, for example, San Francisco, 9th and Geary, we're going to be having a checkpoint tomorrow night on the web.
Do they publish
Now,
all of them?
I don't know. We are looking into this. We think it's a very serious issue.
It's sort of a weak read, I think.
Well,
I would bet to you that I don't know of a police department that in real time would publish where all the checkpoints would be. It would make no sense. And how do they publish it on their website?
As you know, they often publish in general that they're doing it.
So what does that
mean? It was surprising. That means that they believe that these checkpoints provide a deterrent effect. Mm-hmm. And that wider publicity...
But that's a different type of checkpoint.
I agree. I'm just saying we're in the process of looking into it. We think it's very serious. We definitely have a policy that we will not allow apps that encourage illegal activity. And
Apple has pulled bad apps before.
Absolutely.
Okay. You pulled one even about tasteless jokes. Well, this is worse than that, wouldn't you say?
Well, I would say that in some cases it's difficult to decide what the intent of these apps are. But if they intend to encourage people to break the law, then our policy is to pull them off the store.
Then I would suggest that you look at just keeping that policy as is. It's a little different situation than Mr. Davidson. You would find that the intent of these apps is to encourage people to break the law.
And I will take that back, and we will
do different. I know my time is up. I apologize. And I would encourage you to make a distinction between a police department that says, well, we usually have a checkpoint at 9th and Geary, and an app that just talks about where the new checkpoints are and in real time. And you say they publish it. If they publish it 2 days later.
No, I understand that distinction. I agree. That's different.
So you too, Apple will take a serious look at this.
Yes, we will.
I'd like if you folks, both of you, could get me an answer, say 2 weeks from now, as to what is that too soon?
Certainly give you a progress report.
Yeah.
Yes.
How about a month from now as to what your internal examination has come up with? Okay. I thank you, and I thank my colleague for indulging me in an extra 2 minutes. Thanks.
I was actually saying that we were going to go to a second round, not that you were 2 minutes over. I would never do that to the distinguished senator from New York. I'm going to indulge my prerogative as a chair and go to a second round. Mr. Tribble, when you download an app on Android, or on an Android machine, if it tells you that if that app will access your location, your calendar, your contact list, and you get a chance to opt out of those. But an iPhone only asks you if you want to share your location, your location with an app, nothing else. Don't you think it would be helpful for Apple to inform consumers if an app will be able to get information from their calendars or address books? What more can Apple do to inform consumers of the information that an app can access, do you think?
Well, in the case of those things that, the app, we encourage, as I mentioned, and even require the app provider themselves to give notice and get consent from the consumer before they do that. Different from Google in those cases, we do not provide or attempt to provide technical means in all cases to prevent the app from getting at any and all information. In fact, we think that would be very difficult. However, specifically in the case of location, we do make sure that every single time an application, or for the first time an application asks to get access to that user's location, it pops up that dialog box that says this app would like to use your location, yes or no. So I would say that our two things there. One is our priority in this case has been on the especially sensitive nature of location and to provide technical measures or attempt to on the phone to provide that notice every single time when the app first asks. In the case of other information, which may also be personal information, but maybe not, to the same extent as where am I right now, we require the app to give notice and to get consent from the user, but we do not have a technical means to require that. And if we, it's not that we wouldn't want to, we think that's difficult, and it's especially difficult because when you start to do that for every little piece of information, the screen that the user is confronted with in terms of yes, no, yes, no, yes, no, potentially becomes very long and complex.
Well, Google has a screen that contains the number of those, and it seems to work for you guys, right?
It works for us guys, yes.
Okay. Ms. Tribble, well, the ranking member asked you how your companies enforce your own rules for apps. When you were in my office yesterday, and thank you for coming, I actually asked you this question. How many apps have you removed from your app store because they shared information with third parties without users' consent?
As I mentioned to Senator Coburn, of course our first defense is to not put them there in the first place, but if we find an app, we investigate, we work with the developer to get them to give proper notice, and we tell them at some point, if we find them violating, you're going to be off in 24 hours. In fact, I think all of the applications to date, or the application vendors to date, have fixed their applications rather than get yanked from the App Store.
So
in those cases,
the answer to my question is zero?
Zero.
Okay, thank you. Mr. Soltani, let me ask you a different question. Of all the things you've seen, what is the most serious privacy threat that mobile devices pose today?
Sir, thank you for your question. I think the biggest takeaway from this is that consumers are repeatedly surprised by the information that apps and platforms are accessing. Consumers are entrusting their computers and phones and other devices with a great deal of personal information, and to the degree that these platforms are not taking adequate steps to make this clear to consumers, that others in the pipeline have access to this information, I think that's a problem. We've talked about the apps where, a certain app might need access to, I think the example was it needed access to your location information. You said, no, I don't think consumers would know whether apps would need access to certain types of information or not, or could make those definitions clear. And the kind of stemming from that, we see it sounds like the providers of these platforms are actually surprised as well that they're collecting information. In the case of Street View, they were surprised that they were collecting the Wi-Fi information, and in the case of the recent Apple episode, they were surprised that even a year ago they responded to this issue that they were collecting information for a year. And so I think we need improved transparency on this stuff, and in order to do that, we need clear definitions of what things like opt-in mean. For example, the checkbox being checked by default, and you have to uncheck that. Is that really kind of opt-in or is that opt-out? Clear definitions
Sounds
on
like opt-out to me. Yeah.
Right. Clear definitions of what location is. Like if it's if it gets you within 20 feet, is that your location? And then most importantly, clear definitions of what third parties and first parties mean in this context.
Well, could you describe the results of the Wall Street Journal's investigation into mobile apps? Specifically, can you describe the information that apps are getting from users and sharing with third parties? And you tell us. You said they're surprised if the average user has any idea that this is happening.
Right. So I don't think most consumers would know that apps would access things like your location information or information stored on your device. So
your address book?
Your address book, your contact
information.
I think there was a case where Facebook, you would install the Facebook app, and it would synchronize your entire address book up to Facebook's server. I think people were kind of surprised by that functionality. I don't think people realize what the data that's held on the phone versus the data that's transmitted to websites, and then even more transmitted to downstream ad companies and other entities that are not even the website that builds the app. And I think ultimately this might be an issue with regards to kind of the incentives are mixed. So in this context, we have Apple and Google as platform providers, but they're also advertisers, and they also make apps. And so in the example earlier where it was the truck driving and making problematic products, I think in this case we have the same companies that are the truck and the product, and it's really weird to figure out what the incentives should be for them to kind of do the right thing and make intelligent defaults. I think we've seen the defaults fall in the favor of what is in their best interest. Obviously so, they're companies, right? They're commercial entities.
Well, thank you, Mr. Soltani, and thank you all. Senator Blumenthal.
Thank you, Mr. Chairman. And I want to thank all of you again for being here and for your very, very useful contribution to this hearing. Just by way of brief footnote to your conversation, Dr. Tribble, earlier with Senator Schumer, you may or may not be aware, but sometimes police departments actually publicize checkpoints so that drunk drivers will go to alternative routes where they do not publicize the checkpoint. So there may be more strategy than you may be aware in some of the law enforcement practices that are involved here. But I welcome both your and Mr. Davidson's willingness to come back to Senator Schumer with your response. I think that's very welcome and commendable. And I also want to welcome and commend Google's response on the notice issue in case of breaches, which I think is a very important source of support for notice legislation, and would ask Dr. Tribble, I don't think I saw in your testimony, I may have overlooked it, any reference to the requirement for notice in case of breaches of confidentiality. Would Apple likewise support that kind of legislation?
I actually don't. I'm not the policy person at Apple, but what I'll say is that in general we think it's extremely important that information kept on our servers stay secure. We do a lot to make sure that that's the case, and we think that if I personally think if customers are at risk from important information that's leaked from servers, I, for example, as a consumer, would like to know. Fortunately, Apple has not, the case we're discussing is not that here, but if that were to happen, I think that would be something that consumers would want to know about.
Would it be Apple's practice to notify consumers in case of a breach as soon as possible?
Yeah, I believe we're subject to at least various state laws along those lines, breach notification. Although it's not my area of the company, I certainly believe that, I know we would comply with that and notify in case of a breach.
And again, I will be submitting questions that I'm hoping that all the witnesses will respond to, and we're late into this hearing, but I would be very interested in knowing, and would welcome your response here, if you can do it briefly, what additional measures you would suggest. As you may have heard earlier, we asked the panel before yours about requiring security measures, privacy by design, so to speak, as well as remedies such as credit freezes, credit monitoring, insurance in case of breaches, and to prevent such breaches, and would welcome any comments from the panel. Or not, whichever you would prefer.
So fortunately, I actually testified in this issue last week, so I've done a little bit of thinking about it. So from a consumer perspective, there's actually already a pretty strong legal regime in place to require reasonable security practices. The FTC has brought like 30 some odd cases where companies fail to adequately secure data. And for data breach notification, 46 and 47 states have provisions in place. So the legal regime right now already has pretty strong protections in place. The things we would probably look for are, one, more authority to the FTC, maybe greater capacity to bring more cases. I think the 35 they brought are great, but obviously more would be better. And penalty authority, especially as well. The FTC has not had the ability to get civil penalties for violations of the FTC Act. I think if there were a stronger sword, a little stick, I think you would see better practices. Also, I think we'd like to see other of the fair information practices put into law. So one idea that we keep bringing up is the idea of data minimization. If you have data sitting on your servers, you don't need it anymore, and get rid of it. In both the Sony and the Epsilon case, data breach cases, it seems that they were holding old data they didn't need anymore. Sony had a 2007 database of credit card numbers they weren't even using. Epsilon keeping email addresses to people who had previously opted out. I personally got emails from companies I'd opted out from years ago saying, "Oh, by the way, your data was breached here." So I think putting into law protections for data minimization and stronger FTC authority would be valuable things here.
Mr. Brookman, did Sony have in place adequate safeguards?
I'm not, like I said, I'm not a technologist. There have been a lot of press reports indicating that there are things they should have done better. Their servers were not patched to the latest security software. They were holding old data, and their password verification system probably should have been stronger. I'm probably not the best person to testify to that. It's easy for me to sit back and say now that it seems inadequate, but there are definitely strong security minds in the space who criticize what they've done.
Well, in fact, they acknowledge that much better, stronger safeguards should be in place going forward, whether that's an implicit acknowledgement of the inadequacy. Previously, we can't ask them because they're not here today, but certainly they are going to upgrade, or at least have promised to upgrade their safeguards.
Yeah, they've said that they're going to put better protections in place, and so if there were maybe a greater consequences to data security breaches, such as FTC penalty authority, then hopefully companies would maybe think about it more in advance than trying to append security and privacy after the fact.
I have a bunch of other questions which I will ask the witnesses and won't detain you to ask now, but thank you very much, Mr. Chairman.
Thank you, Senator Blumenthal. The hearing record will be held open for a week. In closing, I want to thank my friend, the ranking member. I want to thank all of you who testified today. Thank you all. As I said at the beginning of this hearing, I think that people have a right to know who is getting their information and a right to decide how that information is shared and used. After having heard today's testimony, I still have serious doubts that those rights are being respected in law or in practice. We need to think seriously about how to address this problem, and we need to address this problem now. Mobile devices are only going to become more and more popular. They'll soon be the predominant way that people access the internet, so this is an urgent issue that we'll be dealing with. We will hold the record, as I said, open for a week for submission of questions, and this hearing is now adjourned. Thank you all.
Yeah. And I think telling our audience as well so that they realize that we're in trouble. I mean, even if I feel like
well, I'm going to tell our audience that if we're in trouble, I'm not going to talk. But I don't want to give our audiences to tell them that give them any idea that we are going to be doing this.
Yeah.
Because that's just going to drive them away.
Maybe it's not telling them we're in trouble, and yet we're still trying to do more for you, building that audience, building the kind of coverage we can provide you. Franken just finished, according to David Wall, whatever. Yeah. It literally came up as soon as he looked. Literally, the second you looked, the first two came up on our page that Franken ending. Sorry, I should also. I'm going to head out to the food cart after this and get a black bean burrito. There's a food cart house. There's friends there. Yeah, well, you know, Wednesdays and one they have a food cart food court in St. Paul by the Landmark Center. Yeah. Yeah, but today Simply Steve's is going to be out by the Mears Park. They're on 4th and the road is out right now.